Welcome to Talking Business, your straight-talking guide to dealing with corporate matters. Whether you are a private or public company, an owner-managed business or an entrepreneur, a director, company secretary or in-house counsel, this is the podcast for you. My name is Sophie Brooks and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, hope you're all well this month. So I have got a couple of cases for you, both of them dealing with examples of when paperwork goes wrong, and then a bit of a salutary tale about insider dealing and fines from the FCA. So let's get into these cases. So we often come across these kind of things where there have been problems with the execution of documents, either by companies or by individuals. And it just so happened that there were two cases recently, both of which I thought were worth mentioning. So the first one, the Court of Appeal issued a useful reminder, I think, about the strict formalities required for the execution of deeds by companies. So I think this case really highlights how sort of apparently routine kind of informal practices. So in this case, we're talking about a personal assistant signing on a director's behalf, but that can unravel major commercial arrangements many years later, actually. So what we're relying on here, what we're looking at are the rules in the Companies Act about the different ways in which a company can validly execute a deed, there are three different ways. So you could do it by affixing its common seal. That's pretty rare nowadays. So then the other two methods are both signature methods. So the first one is the signature of two authorized signatories. But when we're talking about authorized signatories here, what we mean are directors and company secretaries. That's it. They are the only people that are authorized signatories for this purpose. So you could have two unwitnessed signatures by authorized signatories, or you could have the signature of a single director, but in which case they must sign in the presence of an attesting witness. Now, in order to protect third parties dealing with companies, the Act provides a statutory presumption of due execution. So what do I mean? Well, this operates so that in favour of a purchaser acting in good faith for valuable consideration, a deed is deemed to have been duly executed if it purports to be signed in accordance with those rules. So, a counterparty to a document executed by a company can assume that a deed has been duly executed by that company, and it doesn't have to investigate whether any appropriate internal authorizations have been obtained. So that's the background. Now, this case, which is called South Bank Hotel Management Company Limited versus Galliard Hotels, and it arose out of the development of a large hotel complex near Waterloo Bridge in London. The claimant, which is South Bank Hotel Management Company Limited, was the vehicle through which investors acquired long leases of individual hotel rooms. So there was a corporate restructuring carried out in 2008. And as part of that, two of the group companies involved in the development entered into two key documents. So we've got a 999-year lease, and then we've got a 15-year underlease. Both of those documents, executed as deeds, stated that they were signed by two authorized signatories, a Mr. Conway, who was the sole director of each company, and then another individual who was the company secretary. But it later transpired that actually Mr. Conway had not signed the deeds. Instead, his personal assistant had just written S. Conway on them at his request. Now, apparently, Mr. Conway frequently asked his PA to do this because he felt that he didn't have time to do so. And he believed mistakenly that this was a valid way to execute the deeds on behalf of the companies. So South Bank later challenged the validity of these deeds, arguing that they'd never been properly executed. And when the High Court rejected that argument, South Bank then appealed. So we get to the Court of Appeal, and that court held that the deeds were not properly executed because the companies had failed to comply with those specific formalities that I told you about that are set out in the Companies Act. So the companies tried to argue that but even if the execution was defective, then actually the statutory presumption came into play. But again, the Court of Appeal rejected that argument. And a key part of the court's reasoning here related to knowledge. So what it said was, well, because Mr. Conway was the sole director of both of the companies involved, his knowledge, specifically that he knew that he hadn't actually signed the deeds, was attributed to the counterparty in each case. And so that meant that they couldn't be said to have acted in good faith, which remember was required as part of the statutory presumption, because they knew that the signatures were not genuine. And in particular, that statutory presumption is designed to protect people who do not know that the position is otherwise than it purports to be, not those who are aware that execution is defective, but actually they proceed regardless. So, another point that the court also clarified was that the statutory presumption operates in favour of a purchaser. So, what that meant was it's intended to be a shield for a purchaser to rely on a deed's validity rather than, as it was being used in this case, a tool for a company to force an invalidly executed deed onto a purchaser who wanted to reject it. So the court held that the two documents, the lease and the underlease, were ineffective as legal deeds. So it's a good reminder there that when it comes to deeds, execution formalities matter. And even sophisticated parties and long running commercial arrangements could be vulnerable if the relevant requirements are not followed to the letter. And transactions that were completed many years ago, which everybody thinks are okay, might still be challenged if execution defects subsequently come to light. And in addition, the statutory presumption will not protect a party that knows, or is presumed to know, that documents have been improperly executed. So what should you do if you've only got one director and your director's not going to be available to actually sign a deed, whether in wet ink or electronically? Well, you're going to need a formal power of attorney in that case. But that power of attorney has to be properly executed by the company. So you're going to need to sort that out in advance. I think the good news here is that e-signing platforms, things like DocuSign or Adobe Sign, they all mean that actually this is less of an issue than previously because, even if your director is perhaps out of the company on holiday, whilst they might not want to be disturbed, actually it's perfectly possible for documents to be circulated to them electronically, and for them to be signed in their absence. Okay, so I mentioned that we had two cases about paperwork going wrong. So in this other one, the High Court stepped in to save an assignment in this case, and it was an assignment of a debt by way of security. So here, the court used the legal doctrine of estoppel to fill a gap in a chain of title where all the parties involved had basically acted on a shared but mistaken assumption that the relevant missing link existed. So we've got a couple of legal concepts involved in this case. So let's just explain those. So first of all, the case involved an assignment by way of security. So what's that? Well, it's a common way actually to back up a loan, basically. So it involves a borrower transferring or assigning in legal language its right to receive a debt to a lender. So then, if the borrower fails to pay back the loan it received from that lender, then the lender can step in and collect the debt that was assigned to it directly from the third party. But importantly, it's only the person that actually owns the debt or has the right to receive it that can assign it. And an assignment will usually be ineffective if the incorrect entity purports to enter into that assignment. But in some limited circumstances, the second legal concept that I'm talking about here, the legal doctrine of estoppel by convention, could save an otherwise ineffective assignment. So the doctrine, estoppel by convention, it's basically a legal safety net that applies when two parties act based on a shared but technically incorrect understanding. And if one party relies on this shared mistake, and it would be basically unfair to let the other party avoid their agreement by relying on the mistake, then the court will stop or estop them from doing so. So let's apply that to this, the facts in this case. So here we've got a borrower that was the parent company of a large private equity firm that owed a significant amount of money to a borrower. To secure an extension on this borrowing, the parent agreed to give the lender a security interest in a debt it was owed of approximately 37 million US dollars. So the assignment agreement was in the name of and signed by the parent, but actually the debt was owed to its subsidiary. So what that means was that the parent was effectively trying to give away something that it didn't actually own, because it was trying to give away the right to receive that money, the debt, but actually the money wasn't owed to the parent, it was owed to the subsidiary. So years later, after the private equity group went into liquidation, the liquidators for the subsidiary tried to argue that the assignment was invalid because it had been signed by the wrong group company. So they were trying to avoid an argument that the subsidiary had given away or the parent had given away that debt, basically so that they could keep the benefit of that debt in the company to which they'd been appointed as liquidators. So when this one came before the court held that, as a matter of strict law, there had been no valid assignment of the debt to the lender. There was no express assignment from the subsidiary to the parent, and no basis for implying that assignment. So basically, what that meant was that the parent had no right to receive the debt, which it could then assign to the lender. So, at first sight, we haven't got a valid assignment. But then the court went on to hold that the subsidiary was estopped from denying the effectiveness of the assignment. And the judge effectively used estoppel to fill the gap created by the missing link in the chain of title. So there were various factors that the judge took into account when reaching that decision. So, firstly, there was a kind of shared assumption between the relevant parties involved. So, the lender, the parent, and the subsidiary had all proceeded on the basis that the assignment granted the lender effective security over the debt. And that wasn't a vague private belief, but it was the foundation of the loan extension, which itself was critical for the whole group, including the subsidiary, who, remember, was now trying to avoid the assignment because the subsidiary benefited from the loans from the lender. Then another factor that the judge took into account was the sort of unified management between the relevant parties. So remember, we were talking about a private equity group here, and it really operated as a single unit. The directors of the parent overlapped with those of the subsidiary, and everyone involved had acted as if the security was effective, including the subsidiary's own advisors. Another factor was the reliance by the lender. So if the assignment by way of security hadn't taken place, then the lender would not have agreed to the loan extension. So the lender was relying on that assignment as part of the transaction. And then basically there was a concept of unfairness. So the judge said, well, it would be wholly inequitable for the subsidiary to enjoy the benefits of the loan extension, but then use a technical group structure error to deprive the lender of its security. And the subsidiary basically couldn't have it both ways. And this was precisely the kind of what the judge called a technical but unmeritorious argument that estoppel was designed to defeat. So the court held that actually the assignment was effective. So that was good news in this case because for the lender anyway, because estoppel rescued the transaction. But it won't always do that, and I would suggest that any attempt to rely on that is likely to be risky and expensive. It's an uncertain, fact-specific remedy, heavily dependent on evidence of that shared assumption and reliance that we did have in this case. But really, you're going to be reviewing that as a sort of last line of defense. And in any transaction, you should be doing proper due diligence up front to establish the true owner of the relevant assets involved. And I would say that is particularly relevant in the case of a group of companies where I think there can sometimes be a tendency for lots of different separate legal entities, parents and subsidiaries, actually to be treated as a bit of a single amorphous whole by the parties involved. And they don't necessarily think about the separate hats that they might be wearing as different directors of different entities. So, a couple of cases there to do with paperwork going wrong, and how in some cases there might be legal doctrines that you can rely on to save it, but obviously the sort of moral of those cases is really to make sure that you properly understand the formalities required for a relevant document to be executed, and then make sure that they are complied with by the correct parties. So finally, then I thought moving on that it was worth mentioning that the FCA, the Financial Conduct Authority, has fined two individuals for insider dealing relating to some trading in an AIM listed. Shares in an AIM listed company. And the reason that I thought it was worth mentioning this was because the total fines, which were over £100,000, were actually more than 10 times the profit that was made by the individuals from their unlawful trading. So it really highlights the punitive consequences of breaching the relevant requirements. So it's the FCA that oversees the UK's civil regime of insider dealing via the UK Market Abuse Regulation, which we refer to as UK MAR. And that regime is built around the concept of inside information, which you might have heard of. And when we talk about inside information, that is information which is of a precise nature, which relates directly or indirectly to a company or its shares, and which crucially is not public, but if it were made public, would be likely to have a significant effect on price. So Article 14 of UK MAR makes it unlawful for a person to deal in shares whilst in possession of inside information, or to recommend or induce that somebody else deals on the basis of that inside information. And it also prohibits the unlawful disclosure of inside information. So there's lots of rules there around what you can and can't do with inside information, or when you have inside information. So it's the FCA that can pursue breaches of UK MAR, and it has the ability to impose unlimited financial penalties, or to require the disgorgement of profits, and to issue public censure of individuals and companies involved. And actually, serious cases can result in insider dealing being a criminal offence carrying a risk of imprisonment. But I think, as well as those kind of obvious consequences, I think for listed companies and their directors as well, the reputational consequences of a breach are often just as significant as those legal ones. And directors in particular, obviously, are sort of particularly exposed under the regime because they are routinely in possession of or have access to inside information. So this case then that I'm talking about, the fines that were issued arose out of trading in shares of a company called Bidstack Group PLC. And that was an advertising technology company that was formally admitted to trading on AIM. So in December 2021, which is when all this happened, Mr. Hirani was the interim CFO of Bidstack. And therefore, as a result, he had access to confidential, price sensitive information, in particular concerning a major forthcoming commercial deal that Bidstack was going to enter into with a large video game publisher. So before the deal was announced to the market, so the information hasn't yet become public, Mr. Hirani disclosed this inside information to an associate, Mr. Karai. Mr. Hirani then opened and operated a trading account in Mr. Karai's name. And together, they purchased about 1.3 million Bidstack shares whilst they were in possession of this inside information. When the deal was then publicly announced, Bidstack's share price increased by more than 125%, and Mr. Karai realised profits of over £9,000. Now, the FCA was actually alerted to the trading through what's known as suspicious transaction and order reports, which we call STORs, and they had been submitted by a regulated firm, so by a firm regulated by the FCA, so maybe a broker or an investment bank, something like that. We don't know the details. So the FCA concluded that both individuals had breached Article 14 of UK MAR by engaging in insider dealing, and also, in Mr. Hirani's case, the CFO, by the unlawful disclosure of inside information to Mr. Karai. So the FCA imposed fines, imposed penalties totaling more than £100,000. So, like I say, that the profit that they made off the insider trading was only about £9,000, but the penalties imposed were over £100,000 in total. And actually, those penalties had already been discounted by about 30% through settlement. So it would have been even more. And in announcing the outcome, the FCA emphasised that the individuals had exploited information that other investors couldn't have known. And it reiterated, the FCA, its commitment to taking action against anyone who undermines trust in UK markets. So the reason we have the market abuse regime, it's designed to ensure that there is a level playing field for everyone who might be interested in buying shares in public companies. So basically, everybody has access to the same information and no one can take unfair advantage of information affecting share price, which isn't publicly available. And the FCA's action in this case, I think, shows that it is going to rigorously enforce those rules in order to help maintain integrity in the UK's markets, that trust in UK markets that the FCA refers to. It also, I think, interestingly highlights the importance of those STORs, those suspicious transaction and order reports, as a source of intelligence when identifying and pursuing potential breaches. So FCA regulated firms are required to submit those STORs when they have a suspicion or have been alerted to some form of suspicious trading. And it's those kind of reports that tend to mean things come to the attention of the FCA. And so you can't assume that your conduct will go under the radar. Okay, that's it for this month. I hope you find those updates useful, and I will speak to you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.